very good evening and welcome to The Big Picture, where we continue to delve deeper into the NJAC debate. After the Supreme Court verdict on the 16th of October on the National Judicial Appointments Commission, when the apex court of the country struck down the proposed change in the system of appointment and transfer of judges by calling it unconstitutional and void, the topic was out in the open for a passionate debate. The government, of course, is working on a detailed strategy to counter what it called a setback to parliamentary sovereignty, and yet again bringing to forefront the judiciary versus executive debate. Well, joining us this evening is an esteemed panel. We, of course, have Dr. Subhash Kashyap, who is a constitutional expert, also former Secretary General at the Lok Sabha. We also have Kapoor, who is, of course, an advocate and also a petitioner in the NJAC case. We have Satya Prakash, who is the legal editor with Hindustan Times. And I believe we also have Supreme Court advocate Kapil Sankhla joining us in just a short while from now. But first, if I could come to you first, Mr. Kapoor, the very fact that the government now is looking at some other options, how do you look at this development?
See, of course, the government always has an opportunity to and privilege to look into various options. The very fact that the government through parliament could enact this law, first 99th Amendment, and then you see a National Judicial Appointment Commission Act, both were put under challenge before the Honorable Supreme Court. The Constitutional Bench ultimately, after a hearing of 36 days, hearing the arguments of the petitioners and Attorney General, Solicitor General and all other group of persons who were in favor of the constitutionality of the 99th Amendment Act as well as National Judicial Appointment Commission Act, ultimately came to the conclusion that both are unconstitutional according to the submissions which were made by the petitioners, including me. Now, the submission before the Honorable Supreme Court was that we have to test the validity of both the 99th Amendment Act as well as National Judicial Appointment Commission Act on the premise of independence of judiciary, which is the basic feature of the Constitution. Of course, Parliament has the power to amend the Constitution, no difficulty, but it cannot amend those provisions which go to the root of the matter and pertain to basic structure of the Constitution, basic feature of the Constitution. And independence of judiciary is one of the basic features of the Constitution, which was, according to the principles laid down by in Keshwarananda Bharti case. Then the 99th Amendment Act made certain provisions by amending and adding 124A, B, C, etc. Now, with the validity of these provisions was challenged because if you 124A, see, it went to the Constitution of National Judicial Appointment Commission comprising of 6 members. And you see 3 members, Chief Justice of India,
Yes.
2 senior most judges of the Supreme Court, and then the Law Minister and 2 eminent persons. And there was another provision, you suppose there is consideration is of a senior most judge who is going to be the Chief Justice of India. He will not be able to participate. So, ultimately, a result would be out of 6 members,
Yes.
only 5 will participate. 2 will be the judges,
Yes.
3 non-judges. So, ultimately majority will prevail. So, they will have to decide who would be the fit person to be a Chief Justice of India. And there also a leverage has been given to decide the fitness of the person to become a Chief Justice of India. Suppose they do not like a person, 2 eminent persons, they can veto. They say that he is not a person fit to become the Chief Justice of India. So much interference with the independence of judiciary. And then not only this, see, if you go to the further provisions 124C,
Yes.
it says, it provided that the Parliament would regulate the procedure for appointment of judges and would empower the Judicial Commission to frame the regulations. It means National Judicial Appointment Commission even does not have the power to frame its regulation till it is empowered by the Parliament. So, every time it has to see the Parliament, you please empower me and let me make my regulation. This is the independence we are talking about. So, then this is the independence which we, and then not only further, I will go further. When National Judicial Appointment Commission Act was enacted, there the provision is that even if the Judicial Commission has framed the regulations, those regulations will be laid before the House of the Parliament. And then Parliament will decide whether those regulations which have been framed by the National Judicial Appointment Commission, whether they should be annulled, modified, cancelled, approved or not. So, even those regulations, they are subject to the final approval of the Parliament. You see how subservient You have made this judicial commission.
But there's also another view to this, which now the government is saying that the judges do not make the law. The legal position is also well settled, is at least what they are claiming. Mr. Kashyap, Dr. Kashyap, what is your stand on this? As you know, as a constitutional expert,
Well,
where do we lie?
First, a small point. So far as empowerment is concerned, it is bound to be the Parliament. Parliament alone can empower. Parliament can empower the Supreme Court. There is no other authority in parliamentary democracy which will empower any institution for that matter. So far as this judgment is concerned, I have a very simple point. The Supreme Court has examined the validity of the 99th Amendment and declared it unconstitutional. When you declare some enactment as unconstitutional, what is the point of reference? The point of reference has to be the Constitution. When you are saying it is unconstitutional,
Yes.
the point of reference has to be the Constitution. Now, where in the Constitution you have primacy of judiciary in appointment of judges or supremacy of judiciary? Where in the Constitution? The Supreme Court should have been able to show us which provision of the Constitution has been violated. How is it unconstitutional? In fact, in all humility, I would say that the Supreme Court judgment in this case itself is unconstitutional. It is unconstitutional, it is undemocratic, it is one-sided. We are a parliamentary democracy, and by definition, in parliamentary democracy, Parliament is supreme. In Britain, Parliament is supreme. They
But
have
not
no
in
written
India.
I am going to say that. Please wait. I did not interfere when you were speaking. In Britain, Parliament is supreme. But in India, Parliament is not supreme because we have a written constitution. Supreme Court is also not supreme except in its own sphere. Parliament is supreme in its own sphere, Supreme Court in its sphere. But overall supremacy does not, I do not agree with the argument of sovereignty of Parliament. Parliament is also not sovereign. Sovereign powers belong to the people of India. And you can say because the people elect the legislatures, and Parliament and state legislatures, therefore on behalf of the people, they exercise their rights. Now, if parliamentary democracy means supremacy of Parliament in Britain, in India we agree that it is not sovereign. But we do not have the American type of supremacy of the Supreme Court. In United States, Supreme Court is supreme.
Yes.
And the Constitution of the United States is what the Supreme Court on a particular day says it is. It is not so in India.
Is that perhaps why we see this friction all the time? Mr. Satya Prakash,
Yes.
if you can join in, the judiciary versus the executive, there's no one particular, as being pointed out, no one supreme here. And that is perhaps why we've always been seeing, if in a few years here and there, we always see that
Each one has to
something like
stay
this
within its sphere.
comes up. And in this case,
Well,
of course,
The Constitution is based on separation of power. And then there is a very fine balance between the three organs of the state. What happened in 1973, for the first time the Supreme Court disturbed that balance by a verdict in Case 1 and Bharti case. In fact, the provision, Article 368, which gives power to amend the Constitution to Parliament, there is only one fetter on that. That is Article 13(2), which says Parliament can make a law, but that should not take away somebody's fundamental right. That's the only restriction which is laid down in the Constitution on Parliament's power to amend the Constitution. In 1973, in Case 1 and Bharti case, for the first time the Supreme Court propounded this theory of basic structure and said no, apart from Article 13(2), here are certain other restrictions which we are imposing. Supreme Court imposed
Yes.
those restrictions, and it said you cannot disturb the basic structure of the Constitution, and that there are certain basic features of the Constitution which cannot be amended even by Parliament. And that is when this friction between legislature and the judiciary started. 20 years after that, in 1993, the Supreme Court started this collegium system.
yes.
they on their own changed the entire constitution. It was a judicial coup because there is no provision in the constitution, and even till today,
Yes.
even after they have revived the collegium system, there is no provision in the constitution which justifies the existence of collegium system. So it's something which the judges have legislated,
Yes.
which this power they don't have. They don't have power to legislate, they don't have power to amend the constitution. In this case also, I can understand they have, for whatever reasons of, they say judiciary's independence is part of basic structure, and hence these two constitutional amendment and NJAC Act both are bad in law, illegal and unconstitutional. I can accept that. But by what power and under which what provision they have revived the collegium system?
Exactly.
Having
And
admitted,
questions-
no,
and yes.
I am saying having admitted that this system has too many faults, it has ignored meritorious people, it has appointed less meritorious people and in some cases very bad people in the judiciary. It is this collegium which recommended Justice Dinakaran, who ultimately faced impeachment. There are 2-3 impeachment proceedings that
Yes.
were started. And again you are saying we will revive this. If it is bad, these two provisions, Constitutional Amendment and NJAC Act, both were bad, you strike it down. But leave it to Parliament, leave it to the wisdom of Parliament to enact fresh laws. You cannot legislate. This way, again, they have transgressed the constitutional limit. This cannot be done. But then, ultimately, this interplay between institutions,
Yes.
judiciary and legislature, and this friction, tussle, it's all part of democratic system.
And the NJAC was supposed to actually replace that collegium.
Yeah, replaced, but
And-
NJAC was a kind of on the part of Parliament also. It was a kind of compromise because having tested this much power in the last 22 years, the collegium would not have, Supreme Court would not have given up.
Yes, exactly.
power.
That's what Mr.
Because
Kapoor,
it
a
was
lot of
expanded
people, a
collegium
lot
it
of
was.
reports that we read, even during the time before even, this order came out, with all the hearings that were taking place, one after the other, there were a lot of views that actually, if you think about it, for once the government has actually, not imposed itself completely. It has involved the other party as well. And in some way, there seems to be at least a balance. Yes, the very fact that there's a law minister on the NJAC, that in itself, of course, was questioned. But still, comparatively, compared to the other times when you see that friction, there was an effort that was made, perhaps, to balance it out a bit. Do you agree at least with that?
See, what the matter before the Supreme Court was regarding the constitutional validity of the amending Act and the National Judicial Appointment Commission Act as it is. The question was not whether the collegium system should continue or not. The question was whether to test the validity of this enactment. Maybe if the enactment was otherwise and the independence of the judiciary was not interfered with, the Supreme Court could have upheld it.
Otherwise means what?
It could have upheld it. The difficulty.
Otherwise means just the judiciary. No government.
No. See, 93 judgment. See, it's wrong on the part of the anybody to say that Supreme Court legislated. No, Supreme Court didn't legislate. The Supreme Court, by the Constitution, has been given the final interpreter of law. After who will give a final interpretation of law? Only Supreme Court, as per the Constitution. See, in 1993, Supreme Court, as per the Constitution,
not beyond the Constitution.
Therefore, when the word consultation in Article 124 was used by the let us say, our constituency debates ultimately led into this expression, consultation. Now, what is the meaning of consultation? See, you, me, we can't interpret it. Ultimately, Supreme Court in 1903 judgment only interpreted what is the meaning of the word consultation. So, this is not a question of legislation, it was only a question of interpretation of expression. Then the consultation means when you have to give a primacy to the judiciary in the matter of appointment, and consultation means concurrence. It means the concurrence, you can't give a lip sympathy to it. Concurrence means when the Chief Justice is giving a certain opinion with respect to a particular individual, then you have to agree with it. See, even during the hearing, a number of hearings which took place before the Honorable Supreme Court, a number of examples were quoted before the Honorable Supreme Court, and even earlier times, before collegium system also. The government a number of times came out with the data to show to the Honorable Supreme Court that even in earlier times before collegium, proper respect was given to the Chief Justice of India, and most of the appointments or almost all the appointments except a few ones, the final opinion of the Chief Justice of India was respected, and all the appointments were made which were cleared with the consent of the Chief Justice of India. It means even prior to collegium or during the collegium, it is always the primacy of the Chief Justice of India. The only thing is a formal concurrence after 93 judgment. Even prior to that, the Chief Justice of India had a role to play and every respect was given to him.
Tell you,
All right.
So
there are
even
three
collegium system
expressions.
also give
I
to
also
that
need to
effect.
introduce our other guest. We've got Supreme Court Advocate Kapil Sankhla also joining us now in this debate. Mr. Sankhla, now that you're joining us, we're of course talking about this judiciary versus executive debate. It's been going on for decades now, but all the more so with the NJAC in mind, and also what's the road ahead that we can see now?
You see, I'm not going to cross horns on the topic whether the NJAC was right or whether the collegium is right. But what I would say as a common man is this, that it is very unfortunate that in a democracy like ours, there is a logger jam between the judiciary as well as the executive, the parliament. And I hope that this gets clarified as soon as possible, because I do understand that though there were a lot of fingers that were pointed out on the NJAC, but similarly, there are a lot of fingers that have been pointed out on the collegium system also. There have been a number of eminent jurists who have raised strong objections on how the collegium was working, as a number of eminent jurists have raised questions on how the NJAC would function. So let me just say this at this moment, that there has to be a via media. There has to be a middle path where I am sure that the judiciary would also like to come out of the closed doors within which they decide something in secrecy and bring it forth to the common man, to the people, to the Republic of India, to its citizens, like RTI has done. Because I think it is now time that India actually opens up, that the doors that close the executive, the judiciary and the other departments all open up, and the common man has a say in the kind of people who are ruling us, as well as the kind of people who are making our laws.
That's right. Dr. Kashyap, that's
One
also...
more thing I would like to add on.
Yes, Mrs. Sankhla, quickly, yes.
One more thing I would like to add on for a second, please, is that something that took place 22 years back after an emergency should not cause acrimony and dispute and problems between the two main pillars of our democracy. We have a three-pillar system where there are checks and balances. Let us always remember that the checks and balances have been there to protect our democracy, which is one of the purest forms of democracy. Let us not have one pillar fighting with the other pillar, or one pillar trying to prove its supremacy over the other, as the NJAC and the collegium dispute has arisen.
Exactly. Dr. Kashyap, that is one of the questions that I had wanted to address. How does the common man view this? How does the common man view this debate that's going on between the parliamentarians and the Supreme Court at this point of time? Because as we have seen in the trend, at least in the past few years, it's the Supreme Court that has acted in certain cases where the government, of course, has been mum upon, whether it's the Jessica Lal case or even others for that matter, where the courts have actually intervened, where the courts have actually gone ahead, with certain cases, and the kind of trust that they perhaps have with the Supreme Court, with the judiciary, is not something that you at least see with, the feeling that you have with parliamentarians. And that is also another thing which is going against, the lawmakers.
So far as the common man is concerned, I think he sees it as most unfortunate, and he is perhaps the biggest loser, and finds the things taking an ugly shape. There is a tremendous disconnect between the political system and the people. The judiciary was supposed to be the last sheet anchor of democracy in our country. And now, the way they are behaving, the faith in the judiciary is also getting eroded every day more and more. So far as the point raised by Shri Kapoor about consultation, we have to read the article 124, carefully, as common man you refer to. Is there any ambiguity there? Is there anything that needs interpretation? It says the President shall appoint the judges of the Supreme Court after consultation.
Yes.
The word used is
Not in
after
consultations, but after
not
consultations,
in
yes.
after consultation. Now, any man with the simple knowledge of language would see that after consultation means that you have got to consult, and you can do the appointments only after you have consulted. So it is not in consultation. It is not open to the wisdom of the blessed judges of the Supreme Court to interpret consultation as something which is binding. And the president and the whole government of India, the elected representatives, reduced to a rubber stamp. What the learned honorable lordships say, they have only to sign on the dotted line. That is not the intention of the constitution makers. Also, I would like to say I can brag about being at least one of those who started all this story of NJAC. I was member of the Venkatachalaya Commission. A distinguished former Chief Justice of India was the chairman, Justice Venkatachalaya. I was chairman of the drafting committee. We, for the first time, mooted this idea of National Judicial Commission. The only difference that has been done by the lawmakers this time, instead of we had suggested one eminent person,
Yes.
they made it two eminent persons. That is,
crucial difference.
but
In a
then,
6-member
but then parliamentary democracy in Britain, and from them we take all the inspiration. And the blessed judges of the Supreme Court, day and night quote the judges of the Supreme judges of the Britain, and treat them as their akas, if I may say so. There is a judicial commission, and they have two eminent persons who need not have judicial background. That is not acceptable. In the whole world, there is not a single country where judges do inbreeding, appoint their own judges. Brother judges being appointed by judges themselves. That does not happen anywhere. As for independence of judiciary, what about the election commission? Is it not independent? Is their independence not valuable? And have there been any charges of any compromises in their independence? Tomorrow they may say that only the election commissioners will select the other election commissioners because our independence is violated. And where is the primacy mentioned in the constitution? How can you bring in primacy
Absolutely,
when it was not
but
there?
at the same time, Mr. Kapoor also did say that we are not talking about the primacy of the Supreme Court as such. But very quickly, if I could bring
Supreme Court
you
is
in,
talking of it. They are
Article-
giving as the main argument
Article
primacy.
141, Article
What we-
141 says so.
may I just say
The
something?
law laid
Only
by the Supreme
declared,
Court.
law
May
declared
I
by the
just say
Supreme
this?
Court.
Mr. Prakash, yes,
But
Mr.
they have to
Satya
declare
Prakash.
the law.
Nine
in
judges
accordance with the
have declared in
Constitution.
second
Yeah,
judges
they
case.
can only declare the law, not make
Mr.
the
Satya
law.
Prakash.
They are
Yes.
trying to
Three
make the law
expressions
and
used.
make the
Yes.
There are three
constitution.
expressions.
See, let me just
One
let me
is-
just say something.
one
I
is
understand. I'm sorry, but
consultation, which
just
is
a
there in
second.
Article
You see,
124.
as far as I
124
understand, that when we are talking about all of these things,
consultation.
Mr.
Right,
Sankhla,
I'm
one
sorry.
second, I'll give you your
By
chance. Yes.
interpretation, the Supreme Court first made it concurrence and then primacy of the CJI, which cannot be done by any stretch of imagination. It cannot be done. The simple English meaning of the word consultation is not what the Supreme Court has ultimately made out to be. That is wrong. One, going by the English language, and also by reviving the collegium system. This is completely unacceptable. And any constitutional amendment, particularly of this nature, Parliament, there was complete unanimity.
Yes.
20 or 20 plus state legislatures, it is entitled to certain respect.
Yes.
Even if you have said that it is illegal, unconstitutional, how can you revive a system which is completely, by your own admission, it is faulty and it is opaque,
Yes.
and it has ignored meritorious people, appointed dubious people. This cannot be done and this must not be done. But then the Supreme Court has fixed November 3 for further hearing
Yes.
to improve
And,
the system.
Mr. Sankhla, last word to you, Mr. Sankhla. You joined us so late. We're giving you the last word.
right. Thank you, so very kind of you. All that I want to say is that, there are very extreme views at this moment.
Yes.
But what we should remember is that the Supreme Court is the last custodian of our democracy. And it did take a big licking during the emergency and post that. So it is right in being very careful and protecting itself and protecting our democracy. But at the same time, We also have to remember that there are other developed nations of the world like UK, USA, Canada, Australia that have a simplistic system of appointing judges not from in-house or inside the judicial system itself, but by commissions or by other various systems that they have. So at the end, what we should realize is that collegium system may not be foolproof, but neither is NJAC.
All right,
So
the government, of course, is doing its consultations. We wonder what action plan it's going to be coming up with. It is going to, of course, be answerable in two fronts.
Absolutely,
one, of course,
yes.
legal and political as well. That's it we have time for on The Big Picture. Thank you so much, gentlemen, for joining me.
Thank
we'll
you.
be back again tomorrow with another topic. Do stay with us.
Thank you.